Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled B-A-K-K-E-R.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high-profile nature of this case, an item of evidence would be submitted to the lab, it would be inventoried by our evidence management group, and then sent to the various units for testing, for example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files
Yes, I do.
and document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All. Spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Burt, are you requesting it to be displayed to just your screens or to all screens?
No, since it's in evidence, Your Honor, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7. Do you see that on your screen?
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says one of 6.
Yes, so this would be the entire document.
Mr. McBride?
And I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
The document is referenced in your report, and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we
Okay.
would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called Statements Not Approved for FBI Autosomal DNA Testimony in Our Laboratory Reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty,
That is correct, it was not.
okay? And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a zero error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a zero error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
A human error could be an error.
Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's up. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does the DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data? So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, Item 7 was the towel. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of A, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars?
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct, and that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex type determining, so 24 total.
What are the sex determining, they're called the locus, correct?
Correct. So locus is that individual section of DNA.
All right, and they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's 2 specific male sex-determining locations. One is Y-indel, and one is DYS385. Those just let me know that those are specific to male individuals.
Okay, and then for the other locations you're looking at, those, you're just looking for 2 types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing 1 or 2 pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low-level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample,
Yes.
yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father, but when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location, so he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now, for that loci, you'd expect 2 types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson is a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 8-11,
That is correct.
but when you looked at the sample, 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing 2 samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct, yes.
And do you generally like to keep up with that literature?
I do, yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct, yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that, yes.
That's an authoritative book that was really one of the first books on DNA testing,
Yes,
all right? And then by the same organization, National Research Council, the Evaluation of Forensic DNA Evidence,
correct, yes.
published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI, named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct, yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing,
Yes,
familiar with that. Forensic DNA Typing Methodology,
yes, I'm familiar with that one as well.
and Forensic DNA Typing Interpretation.
Yes,
Everybody in your field relies on these publications and use them as teaching tools.
yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes,
This case, we're dealing with mixtures, correct?
yes,
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that challenge exists in situations where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes,
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
that is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414, correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident, based on our validation, our testing, and my training, that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14, 15, I will not automatically exclude them.
What is stochastic effects?
Stochastic
I'm
effect,
going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All
I
right.
think
Mr. Burt?
it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
And in regards to this line of questioning, how far are you going to go on this line of questioning?
I have this one question, and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right. And they also did a follow-up report to assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST report specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So,
Correct, yes.
and the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of Investigation?
Objection, Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence at this stage. I think we're far into 702 territory at this point.
Mr. Burt.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the light most favorable to the state. And I think we're beyond that point now. We're getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
NOC stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, is it not?
Not necessarily.
But it can be in some cases, correct?
It could be, if there's mixtures of a lot of individuals and a lot of the peak heights, the size of the spikes are relatively the same, it could cause some some trouble for me as an examiner.
All right. One of the groups that studies your field is the National Institute of Standards and Technology, correct?
That is correct, yes.
They're in the Department of Commerce,
I believe so, yes.
federal agency.
Yes.
And they published a report in 2024 called Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. You're familiar with that publication, right?
I am, yes.
And was that a publication written by scientists?
I don't recall exactly who the authors of that publication were.
Okay. Just make sure. That it's a long report, right?
Yes, it is.
And you've read it.
I've read highlights of it.
Is it true that one of the things that they say in that report is they have a section on the complexity of number of contributor estimations?
Objection.
Are you,
Same objection, Your Honor. This is beyond the scope of a preliminary hearing. Again, we're talking about expert reports. We're talking about scientific studies. These materials are all fine to consider at a 702 admissibility hearing. At this stage, where, again, the evidence is viewed in the light most favorable to the state, this is unhelpful to the court's determination, and therefore irrelevant to this proceeding.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, I think the report that the state put into evidence, as clarified by this witness, indicates that she reached the conclusion that Mr. Robinson and Mr. Twiggs were, quote, possible contributors to these two samples. And so the one thing the court has to weigh is what is the weight of that opinion given the science or lack thereof? And one of the important issues here is how she derived these statistical numbers. And as an offer of proof, I'll indicate to the court that the numbers derived from this software program, and that software program is dependent in large part on how many contributors the analyst puts into the input of the software. And the numbers can change if the number of contributors is changed. And in this case, as I'll show through the examination, this examiner originally thought there were 3 contributors. And I will show to the court why she changed her analysis, and will indicate through this publication that there has been criticism of the way in which she determined the number of contributors. So I think it's important for the court to assess whether you've got accurate numbers in front of you. The state put in these astronomical numbers and are asking the court to give weight to them. And I'm asking the court to consider how those numbers were arrived at and whether there are reliability issues with regard to those numbers.
So the concern that I have is, I turn to State v. Ramirez, 2012 UT 59 at paragraph 10. It states, furthermore, the magistrate's role does not encompass an assessment of whether such inference is more plausible than an alternative that cuts in favor of the defense. That is a matter of fact-finding, which is left for the jury at trial. And so when I'm staying in my role as a magistrate, I hear what you're saying, but my concern is based off case law that dictates what I as a magistrate should be doing. If I want to stay in that lane, my fear is as we go down further down this path, which again is not precluding if this were to proceed, if there were a bind over, if there was a trial, that certainly that could be determined. But at this point, at this stage, how do you weigh this issue as I'm weighing State v. Ramirez in deciding whether we're going past the probable cause stage?
Sure, and I think the answer to that is we have to take into account the ruling that you made in this case, which is the law of this case, which is when we objected to the hearsay aspect of these DNA reports and other reports, you ruled that you are the ultimate determiner of the reliability of the hearsay evidence being admitted. And you will recall that our argument was the statute was unconstitutional because it was dictating that you find certain evidence to be reliable without considering whether it was reliable. And your ruling, as I understood it, was no, you retain the ultimate determination of whether the evidence is reliable. And that's not a credibility issue. It's, is this reliable hearsay that the state is offering? And so issues that go to whether these numbers that the state is putting in front of you are reliable, I think go directly to the substance of your ruling, which is that your role here is to determine reliability of evidence. And I'm familiar with a case that the court cites, but I think that has more to do with weighing evidence and making credibility assessments, whereas I'm focused on what the court ruled, which is we have to look at reliability here. And that's my job as a magistrate.
Mr. McBride, any final thoughts?
Yes, under Rule 1102B4, this, the Exhibit 31 is considered reliable hearsay. In addition, credibility determinations are not proper for the court to make here for the whole reason that, you know, studies supporting this science, studies opposing this science, testimony from this expert or that expert about what is reliable, what is not, what's more reliable, what's less reliable, factors that affect all those determinations. Those are all very, very complex decisions. There will be probably multiple day hearings dealing with that, and a probable cause determination is just not the place to conduct that kind of thorough, in-depth, and searching analysis. Rather, the case law, the Constitution of Utah that says the only purpose of a preliminary hearing is determining probable cause, the case law, the rules that all say the court does not weigh the evidence at this stage, but leaves that for a finder of fact, the jury in the end. That all supports cutting this line of questioning off at this point rather than going on for into greater depth, Your Honor.
All right. Well, based off what's been presented before me, I'm going to sustain in part and deny in part the objection made. I'm going to allow this question to be asked, and so that is denying, but sustain in the sense that this would be the last question, and if Mr. Burt would chooses to, may go on to a different subject or a different line of questioning.
Sure. Did that NIST report conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
Can you repeat that?
Yeah. Did the report, the NIST report that you referenced, conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So, like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have, as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how StarMix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first time I run StarMix, I'm not going to get a likelihood ratio of 10, and the second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time, but even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. I think you need to scroll up one page. There we go. Can you identify this page from your notes?
Yes, I can. These were notes that my technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms, or the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
I move into evidence page 365, and that would be Baker 4.
Mr. McBride?
Yeah, I'll object on relevance grounds.
All right, did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors, and I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right, so as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, that these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant
Your
and
Honor.
that it is admitted into evidence. As regards to publication, what is the request?
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to
I
make
did.
sure. I want to make sure. Are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
These are notes in my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer that you relied upon.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. And so the question I'm trying to get to, counsel, is, was this particular, I recognize it as it being prepared by someone else, but as it relates to State's Exhibit 31, was this relied upon in order for State's Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth. Those two reviews have to be done before I can actually make it a final report and case file that gets submitted and sent to the field.
And in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, at that particular time, I had a reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you changed your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes are kept in the ordinary course of your business?
Yes.
And they're part of the case file that you rely upon in reaching your conclusions?
They are kept with the case file after I draw my conclusions.
So, Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
All right. Anything further from the parties before I weigh in on, make my ruling on Baker 4?
No.
The court finds that it is relevant, and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published.
All right, in the courtroom.
in both the courtroom and to the cameras.
All right. Any objection, Mr. McBride? All right, we'll go ahead and publish that to all screens and may be captured by the media.
So these notations at the top there, 7-1 male, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on our discussion.
Okay, so was that an extended discussion you had with her, or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Yes, it is.
I move that into evidence, Your Honor. This would be Baker 4, page 128.
Oh, I thought I already admitted Baker 4. Is this a different? The previous one was Baker 4, as I understood it.
Yeah, Baker 4, page 365.
Oh, okay. So
And
Baker.
so this is Baker 4, page 128.
Right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
If I could have just a minute to update my notes on those page numbers.
All right. 365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
This is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be, these are going to be offered as exhibits, so I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing, but with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropharogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropharogram to reach the conclusions that she reached, that there were 3 and not 2 contributors. And I think it will assist the court in determining exactly how this comparison process works and what the output looks like, so the court can see exactly how the interpretations are being made.
And is this the dose that were relied upon so I'm viewing today's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line, she will say, and just to let the court know in responsive to Mr. McBride's statement that he was unaware that this is going to be an issue, he and I met with this analyst before the preliminary hearing. The analyst pointed this page out to us as being illustrative of why she originally concluded that there were 3 contributors. So this is not something that's being sprung on the state. He was a part of that conversation, and this particular page was identified by the analyst, not by me. So it is important to understand why we went from 3 to 2 and what impact that has on the numbers that the state is offering.
All right. Anything further?
No.
All right, under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay, you can.
Was that a
Publish.
yes? Oh, okay.
Yes.
All right, so published, I'm assuming to that
Yes.
screen as well? All right.
Correct.
It may be published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, it is admitted, and you may discuss it, but I definitely want to keep this within the track of probable cause.
Understood.
All right.
Thank you.
Mr. Burt.
Okay. Is it true what I just told the court, that you pointed this particular page out as illustrating why you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropharogram?
Yes, this is an electropharogram. Each of those rectangles at the top, for example, D2S441, that is that small segment of DNA that I referred to earlier. And each of those peaks has a corresponding number that is the allele, so that corresponds to the number of repeats that an individual inherited.
And this is what you ultimately, after you get this electropharogram not through running it through STR-Mix. There's a different device that you use to produce these electropharograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropharogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize, but there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize that says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see, so how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same thing for the next D19S433 and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine could there potentially be a third person included. So for example, at D2, the location farthest to the left, I'm asking myself that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
You use a phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor.
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that consensual partner. If I see that they're present, I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those two samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present?
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
Right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up STAR mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this HP is the prosecution hypothesis, right?
Correct, yes.
And HD is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It would
to
be a
take
great
15
time, Your Honor.
All right,
Thank
let's
you.
take a 15-minute break. Let's see. We'll come back at Baker, direct examination.
Thank you.
Mr. Burt, your witness.
Ms. Baker, would you take a look at, in your notes, page 24 of 379? Very bottom of the page. Did you write there on the 15th of September 2025, spoke with Special Agent Folger, gave update on report timeline, discussed that upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional. Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence, and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh,
Yeah, it should not be on the screen.
let's pull it down from the screen. Thank you.
Thank
So
you.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report, I'm sorry, the STAR mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twigs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
And move that into evidence, Your Honor. This would be Baker 38, page 39 through 44.
Baker 38, page 39 through,
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine
Let
how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough to admit it.
Understood, and I apologize to the court. So the report that was admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twiggs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, Baker 38, pages 39 through 44 is admitted and may be published. Again, as a reminder, for all attorneys, this is a probable cause standard, so if all parties can just keep that in mind as we're moving forward on this.
Sure,
Thank you.
thank you.
And so it may be published to all screens.
Bates number on this?
Yeah, it's page 39.
No, but the actual Bates number, I'm happy to provide the file and provide this to the
So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes,
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
that is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input. You tell the software program, assume there are two contributors, right?
Correct, yes.
You input sample 7A,
Correct, yes.
and when you input it, it's just the raw data, right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis,
Correct, yes.
right? And you put in sample 61, right?
Yes,
That's Twiggs's known sample.
correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay, and then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of two different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those two numbers.
That's pretty technical stuff, but the bottom line is that the software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right, and why is one column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an FBI population database on Bahamians,
And African Americans, yes.
African Americans. Another one for Caucasians,
Correct, yes.
SEH is Southeast Hispanics,
Correct.
and then Southwest Hispanics.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing. State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited, all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're far beyond a probable cause hearing, Your Honor. I would ask the court to sustain the objection, not allow questioning on this or any other matter that does not deal with the issue of probable cause.
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to 2 samples that were found at the crime scene. They obviously think that's relevant to the probable cause inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide it's not relevant, it's not reliable, therefore I'm not going to rely on that in determining probable cause. And that, or the court could say it is reliable and it bolsters up other evidence that the court is going to hear from. So the particular report in front of us goes directly to the issue of whether the expert correctly concluded that Twiggs not was a possible contributor, but was a contributor. And the state's theory here apparently is that both Mr. Robinson and Mr. Twiggs are somehow connected to this crime scene. So I think when the court sees what the numbers were generated and how that compares to her own standards for assessment, the court will see that the conclusion is not justified that she reached.
All right. Well, I understand what both parties are saying, and at a probable cause hearing, the issue is whether we walk 1 mile or 100 miles down the path, and so I want to keep it limited to 1 mile, and as opposed to 100 miles, because that would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as
Yes,
opposed
I
to
can do
going
that.
through all this, so we can move on to whatever else you would like to present.
Thank you. We'll do that, Your Honor. And in the interest of doing that, could you bring up on the same screen part of her report, People's Exhibit 31?
And let's take that off.
Oh, I'm going to need that up there because I need to do
Oh,
it.
so is it part of the same, because it was on that screen, I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted, compared to people, or plaintiff's exhibit 31, which
I
has
see,
also been
okay.
admitted.
Okay,
So
thank
they're
you. I
both-
just wanted to clarify.
Sure.
All right, so if you, and do you want that published on this? all
Yes.
screens? All right, let's go ahead and do so.
And the chart I would like you to bring up from that report is on page 5. Yeah, and just highlight that. Thank you. So what we've blown up there is from your report, plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay, and on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion, and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay, if you could not reduce that. And go to page 2 of the report on the left. So from this chart, when you ran Mr. Twiggs against the sample, what was the likelihood ratio that you determined?
I believe this chart is not the comparison to Mr. Twiggs.
That's not in the report?
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twiggs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor, or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. You relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR Mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the STAR Mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run STAR Mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electropherograms.
That is correct, yes. Mr. Twiggs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twiggs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
Let me ask you about your interpretation rules for excluding someone. Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout. So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Okay. At Tho, what was Mr. Twiggs's type?
He was a 7 9.3.
Did you find a 7 allele in the 8-1 sample?
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so there was some dropout. So did you assume that at that location that the allele that dropped out matched his allele?
At that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received this, the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack, correct?
Correct, yes.
You were initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we process them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the backpack belongs to Kirk's detailees.
Yes, based on the individual that was not my communication log, that was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
And why did you do that?
That is part of our protocols, that we have to request permission to consume, and we consume, so DNA, we can't see it, so when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory have a policy, standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract?
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid that was left and returned.
On some of the items, right?
I believe on all of the items.
Well, we'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And then is there also a similar policy from the quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when the laboratory may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were destroyed, consumed, correct?
That is correct, yes.
And which samples were consumed?
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right? You split the swab and you use half, you save half so that your testing results can be replicated and retested.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA. Or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs, and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay, and what did you have left after you did that in terms of the volume of extract? What was left?
So it was approximately 3 microliters, so a very small portion.
Very small portion, and you actually used 10 microliters to do your testing of those samples, right?
That is correct, yes.
So if you didn't get any results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same stairwell, and they were packaged together. So our policies and procedures is that we can combine those 2 together.
And when you do that, you create a mixture, right?
I don't know that I would agree that combining the 2 would create a mixture. Given the item of evidence, a stairwell railing, I don't necessarily expect that one swab would have one person, the second swab would have a different second person, and combining the 2 of them creates a mixture. However, I don't know that for certain, but again, I don't know is DNA present, so our procedure is to combine and consume those swabs.
Okay. And in this case, when you did that, what you got was a complex mixture, right?
I did. I got DNA from more than 5 individuals, so I could not provide a conclusion.
All right. Now,
Mr. Burt, and we are at the 4:30 point. I just want to inquire, without
I just
applying
have
pressure,
one
just trying to
area left.
understand. Okay.
no, be done with it. We talked earlier about your testing of the length of the DNA sequence, the length of the DNA boxcars, not the sequence of A, C, T, and G within those sequences, within those boxcars, right?
Correct, yes.
And is it true that there are different alleles that have the same length when you measure by STRs but have different sequences?
Yes, that is possible.
And I'd like to show you a chart that you have reviewed, I believe. This is, could you bring up 34? This is not in front of the, on the public screen, just for the witness. And is this a chart that you reviewed, that I prepared to, and you looked at to see if I had correctly stated what alleles were found?
Yes, it is.
And does it, as it's presently existing, accurately state what the alleles are at each
Yeah.
location?
Yes.
Okay. I would move that into evidence. It's 5 pages and it's Baker 34.
Mr. McBride?
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt?
Your Honor, this exhibit and the next one go directly to whether the comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right? And maybe it's just because it's late in the day. Could
Yeah,
you
it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs and Mr. Robinson, and for the evidence samples, the 71A and 81A. The other alleles are on here as well, but we're going to focus on 71 and 81. And for instance, Your Honor, at the, you'll see that under the first reading there is for Tyler Robinson at the D3 location. He is a 17. Okay, and take that down. And then if you go down to the 7-1 towel sample, which is what the topic is of this report introduced by the state, you'll see that she found a 17 there as well, measured only by the length of the DNA strand. And what she's going to testify to is at this location and 5 or 6 others, there are alleles, all of which measure here 17, but actually contain different sequences. And that her testing that she used does not measure for those differences.
And so as it relates to probable cause, that's what I want to keep coming back
Sure.
to. Again, if this was a trial, this may be a little bit different analysis that the trial judge applies. But as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
So it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish, and I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently. And I think it is important for the court to consider, especially as it relates to the comparison to Mr. Robinson.
Mr. McBride.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent, and that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness, and so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations, relevant to the comparison to Mr. Robinson. And when the state says the court cannot weigh it, the court can weigh reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, tell the court whether there are differences between, at these 5 locations. She can't match Mr. Robinson to the question samples because she didn't do sequence testing. And she'll also testify that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker 34, but Mr. Burt, I'm going to limit you to how much time do you need to address
I just
this?
need about 4 or 5 minutes. I'm going to, the next chart will be the chart with the, what are called isoalleles displayed for the court, so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that, in fact, I've accurately stated what the alleles are that have sequence differences.
All right. So it is Mr. McBride.
Just on a second matter, which is I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the I accept Mr. Burt's representations the amount of time, and I'm going to talk less because that's consuming more time, and also allow the state the appropriate time for cross-examination given the nature of this witness having to travel. So, Mr. Burt, I'll turn to you. This has been moved into evidence. Do you want it on the screens?
Actually, I don't need it on the screen, just in the interest of efficiency. Pull up the next one, please.
Okay.
I'm on 35. Take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those 3.
Correct, yes.
And similarly at VWA, where you say that the Mr. Robinson is an 1819 and 1819 in the evidence sample. There's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right, I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at well, I'll save that for redirect.
Afternoon.
Good afternoon.
I want to start by asking you what your training and experience is. First of all, do you have any education?
Yes, I do. I have a Bachelor's of Science in Biology from Salisbury University.
And do you, after your bachelor's in biology degree, what did you do for your career and in further education?
Upon graduating from college, I began working at the FBI laboratory as a contractor. I was assigned to the Federal Convicted Offender Program, which was a program under the DNA unit. During that time, I did that for approximately a year and a half. It was my responsibility to open and inventory and barcode DNA collection kits sent in from federal agencies across the United States. I then became a biologist in the DNA casework unit. I did that for approximately 6 years. During that time, I did the actual testing of items of evidence, so swabbing, cutting those swabs, producing the DNA profile. And then in 2015, I accepted a position as a forensic examiner, which I am still today.
I'm sorry, what year was that?
2015.
So 11 years, you've been doing more or less the same duties you have now, is that right?
Correct, yes.
I want to ask you about your lab's accreditation. What is accreditation for a laboratory?
Accreditation is a formal recognition that our laboratory is following a very strict set of standards. We're accredited by ANAB, the American National Standards Institute National Accreditation Board. And our accreditation shows that we have to follow standards such as I have to have a certain education background, how we process evidence, how we store evidence. Every 4 years, we're audited to those standards, meaning an outside body will come into our laboratory, look at my training records, look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there as a scientist there for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay results, those scientific results, to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education, and this can be done by attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures will work within our laboratory. Based on the validation, we create something called standard operating procedures, or SOPs, and these are kind of like cookbooks. It gives us step-by-step instructions on how to do our process and procedures. And then both myself as an examiner as well as the biologists were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call StarMix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally. Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used, how widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
I want to go back to some of the questions that you were asked on direct examination. You were asked about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language, what does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know, let's see, the directive from the Department of Justice limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to submit the statistical number and let others decide, meaning the reader decide how they want to describe that number. Is that accurate?
Yes, it is.
So for example, if we can look at Exhibit 31, if you don't mind publishing that. Yes, and that's been admitted, so if we can put it on the screen. And Kimberly, if you could scroll to page 3 when that comes up. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in a written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down, thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Oh, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids, such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the item. So again, if a firearm, for example, is in a river, I would expect with the water rushing over that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there was some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel, or the swab from the towel, there was slight degradation, not as much as Exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
You're asked about a PCAST report. You testified that that gave guidance on different areas of forensic science. Do you know what year that report was published?
I don't recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area, yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about Exhibits 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%, and the ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculated the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so, well, do you have Baker 4 365? Put that up. And item 7 is the towel, right?
Yes,
Item 8 is the screwdriver.
correct, yes.
Thank you. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry. Thank you for helping out with that. In reaching your conclusions, did you follow the protocols of your accredited lab?
Yes, I did.
And based on your training and experience in following those protocols, did you in fact come to the conclusions described in Exhibit 31?
Yes, I did.
Right, Mr. Burt? And how much time are you anticipating? All right.
You referred on cross-examination to your training and experience, right?
Yes,
Do you agree with this statement in the PCAST report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't.
Okay.
I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data, so that does help me come to a conclusion.
Do you agree with this statement by that same report? Good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and that it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right? Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory. And the PCAST report said that we need validation data not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe they did, yes.
Yeah. And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes,
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
no, I'm not.
Okay, thank you, that's all I have.
All right. Anything further for this witness?
Yes, I think there's one follow-up needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in
Ye-
essence.
Yes.
Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carer.
And Ms. Garner, what do you do for a living?
I am a firearm and toolmark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there? What area of expertise do you have?
I am assigned to the firearm and toolmark unit, so I receive items of evidence related to firearms, tools, toolmarks, and fired ammunition components.
At the request of the state of Utah, did you conduct certain examinations relevant to this case?
I did, yes.
Could you bring up State 32 in evidence?
And do you want it, Mr. Burt?
Yes, I think.
On all screens?
All screens, it's admitted and
Okay.
I think approved
All
for
right, let's go ahead and put
publication.
it on all screens because this was admitted and published previously. All right.
You recognize plaintiff's exhibit number 32?
I do, yes.
Are you the author of this report?
I am, yes.
Okay. What were you asked to do in relation to the examination that's documented in this report?
For the Submission 1 report, I received a firearm, cartridge case, 3 cartridges, 1 bullet jacket fragment, and 4 lead fragments. I was asked to test fire the firearm and compare the test fires to the cartridge case and the bullet jacket fragment. I also was asked to do a tool mark characterization on the cartridge case and the cartridges, and then I also ran a general rifling characteristic search on the bullet jacket fragment.
Okay. And are your conclusions accurately documented in your report?
Yes.
Could you turn to page 2 of the report? Second, bottom of the page. Those 2 paragraphs, please. Did you write in your report, these conclusions conform with the relevant Department of Justice policy on uniform language for testimony?
Yes, that is always added to our reports.
And do you have a standard operating procedure that requires that in each examination you do, this language has to be in there?
We do, yes.
Okay. And I want to ask you to review the document that is referenced in that language, which would be, and this is just for her only, Exhibit 11. Let me know when you can see that. Are you able to view that?
Yes,
Is this the ATS, is this a language referred to in your report?
it is,
The
yes.
written policy of the Department of Justice concerning uniform language for testimony and reports for the forensic firearm toolmark discipline pattern examination.
It is, yes.
I move that into evidence.
This is, what is the title of this exhibit?
Your Honor, this would be Carner 11.
All right, and what level of publication are you requesting, Mr. Burt?
Both public and admittance into evidence.
To the state.
No objection.
All right, Carner 11 is admitted into evidence and may be published on screens and captured by the camera.
Thank you. And you can publish that? Ms. Carner, can you tell us what the purpose and scope of this document is?
Yes, this is the DOJ Department of Justice's uniform language for testimony and report, and it standardizes the appropriate language an examiner will use during reporting and their testimony. And DOJ published this to standardize the wording that examiners would use across their forensic laboratories.
And was this published in part because of some criticism that the prior testimony, not by you, but by other people, may have gone beyond the bounds of science?
I don't know why DOJ published it. It was before my time.
Do you know how long this has been the policy of the Department of Justice?
I do not off the top of my head, no.
Are the reports that you issued in relation to this case in conformity with this policy?
They are, yes.
Okay. Now, could you go to page 3 of that report? Where it says qualifications and limitation of firearm toolmark discipline examination. You're familiar with that part of the policy, correct?
I am, yes.
And the portion of the policy that says a conclusion provided during testimony or in a report is ultimately an examiner's decision and is not based on a statistically derived or verified measurement or comparison to all other firearms or tool marks. Therefore, an examiner shall not, and then it lists several propositions. You're familiar with that language?
I am, yes.
And it says that an examiner shall not assert that a source identification or a source exclusion conclusion is based on uniqueness of an item of evidence. Your report is not meant to imply something contrary to what's stated here, is it?
No, it's not meant to contract.
You're not asserting that a source identification is based on the uniqueness of an item of evidence.
No, I am not.
And the reason you're not doing that is because you haven't examined all possible items of evidence that could be relevant to your comparisons, correct?
I have not looked at every firearm that's been manufactured in the world, nor have I looked at every tool that's been manufactured in the world. That's correct.
Okay. The second portion of that says an examiner shall not use the term individualize or individualization when describing a source conclusion. Did you abide by that policy in this case?
I did, yes.
And you're not expressing an opinion here that the comparisons that you made are individualized to a particular weapon or a particular cartridge case, correct?
My conclusion for one of the exhibits identifies the cartridge case as being fired in the firearm. But that's all it says, yes.
Right, but you're not asserting that that's an individualized identification in the sense that's being used in this policy, are you?
No, I am not.
Okay, and then the third part of that says that an examiner shall not assert that two tool marks originated from the same source to the exclusion of all other sources. You're not expressing that opinion either, are you?
I am not, no.
It says, an examiner shall not assert that examinations conducted in the forensic firearms toolmark discipline are infallible. You're not asserting that?
I am not, no.
You're not asserting that, it says the examiner shall not assert that there is a zero error rate. You're not
Correct.
making that assertion,
No.
okay? Says an examiner shall not provide a conclusion that includes a statistic or numerical degree of probability except when based on relevant and appropriate data. You didn't conduct such an analysis here, correct?
I did not, no.
Okay. And it says, an examiner shall not cite the number of examinations conducted in the forensic firearm toolmark discipline performed in his or her career as a direct measure for the accuracy of a conclusion provided. You didn't do that, and you're not doing that here, correct?
Correct.
And then it says, an examiner shall not assert that two tool marks originated from the same source with absolute or 100% certainty, or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony, unless required to do so by a judge. You're not making any such assertions in this case, are you?
I am not.
Okay. All right, thank you. You can take that down. Now, when you conducted your analysis in this case, and in all cases, do you typically generate a case file that includes proper documentation of your examination?
I do, yes.
And did you do that in this case?
I did.
Could you display to her alone, please, Exhibit 6, Carner 6? Case file. Yes. Do you see what's displayed there?
I do, yes.
It's a 47-page. Is this your case file?
It is, yes.
Did you rely on the documents and photographs that are documented here in writing the report that the state introduced into evidence here?
How so?
Before you wrote your report, did you photograph items that you were looking at, take other notes, and then use that work product to form the opinions you reached that are documented in the report?
The notes are mostly used for initial documentation and evaluation, and then, yes, supplement to the conclusions that I make. It's all a representative image of what my conclusions are going to be. So part of it is going into the conclusion statement and then just showing proof of those conclusions.
Right, and your standard operating procedure requires that you document in your case file the basis for your opinions, correct?
Yes.
I'd move Carner 6 into evidence?
To the state.
Is this the 47-page document?
Yes.
Yeah, I object. I don't see the relevance to the court's probable cause determination to review a 46-page report that includes notes.
Would you like to respond, Mr. Burt?
Yes, Your Honor, this is the basis and documentation of the conclusions reached in the expert's brief report, which expresses her ultimate conclusion, but does not contain any of the reasoning for that conclusion.
Yeah.
Thank you. Ms. Carner, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you opened, what was it, an envelope?
A small individual manila envelope, yes.
And did you take the contents of the envelope containing the bullet and take photographs of it?
I did, yes.
Okay. Could you display page 41 of 47, of that exhibit? I'm sorry, page 14. And tell us what's depicted here.
Yes, this is a picture of the as-received condition of Exhibit 6 in its entirety. That's the top picture. So you'll see Exhibit 6A all the way through 6E in descending order. And then the bottom 2 photos on the left is the Exhibit 6A bullet jacket fragment, and that is the view of the exterior. And then the photograph on the right is the Exhibit 6A bullet jacket fragment, and that's the view of the interior of it.
Okay. Now, after you documented what the bullet and the fragments look like, did you do certain procedures on the bullet, the larger bullet fragment?
I did, yes.
And what did you do?
I cleaned the bullet jacket fragment, and I also peeled the petals back. If you think of a banana and peeling the skin away from the interior, it's almost like doing that. As you can see from the photo, the petals have been crumpled in on themselves. So in order for me to see the land and groove impressions, which holds those individual characteristics needed for a comparison, I have to do some maneuvering of those petals.
And how do you do that? Do you use an instrument to peel back the portions that you want to look at?
I use pliers.
Okay. And after you did that procedure, did you then photograph the larger bullet fragment itself?
I did, yes.
Were the smaller fragments essentially not of any value to you in terms of doing comparisons?
They were deemed unsuitable, which means there are no microscopic marks of value for comparison.
Okay, but the larger fragment, after you did the process you just explained, you then photographed it again, correct?
That is correct, yes.
Could you display the next page of this exhibit, please? Tell us what we see here.
This is 2 pictures of that 6A bullet jacket fragment after the examination preparation. So the top photo is going to be the interior of 6A, and then the bottom photo is the exterior of 6A.
Now, after you took these photographs, did you proceed to do something to determine whether you had either class, individual, or subclass characteristics?
Yes.
Tell the court what that means.
To start, when I do my initial examination of a bullet jacket fragment like this, I'm going to look at its class characteristics. Class characteristics are the least restrictive set of characteristics I use in my comparison process. And these are design features that are given to a large group of items that characterize them together. So for a bullet, you could think of the diameter of the bullet, the number of landing grooves, the direction of twist, and the type of rifling. So I would go through and look at the class characteristics of this bullet jacket fragment, which was 6 right conventional rifling. Then I'd move on to look at any subclass characteristics. And subclass characteristics are more restricted than class, but less than individual. And they are design features that can be put on an object during the manufacturing process, which is consistent among items that are made by a tool that's in a specific state of wear. So what I mean by that is it's going to be a subset of a larger group, which is why it's not used for identification or comparison purposes for the basis of a conclusion. But when you think of something that's made through a mold process, when that mold comes together, it creates a seam line, and that seam line is going to be represented on all the items that it makes. So that's why you can't use it for the identification process, because it's going to be on a lot of items, which is why it's a subset of the group. Then I move on at looking at the individual characteristics. And these are imperfections and irregularities that arise from the manufacturing process. And then there's also individual characteristics can arise from wear, use, and abuse of a tool. And these individual characteristics is what is going to be distinct to that tool, and that's why they're used for the identification process. So again, I did an examination of its class characteristics, looked for any subclass characteristics, and then looked to see if there was individual characteristics in the land and groove impressions sufficient enough of marks and values to do a comparison process.
Now, once you have the class characteristics of a bullet, can you narrow the range of firearms that could have fired it just based on class characteristics?
You can, yes.
And is caliber a class characteristic or an individual or a subclass characteristic?
It's going to be a class characteristic because a lot of firearms will have the same class, or excuse me, the same caliber.
Did you measure the diameter of the bullet?
I did, yes.
And did you end up with a range where it could have been a certain range of length or diameter?
I did, yes.
And what was your reading?
Can I refer to my notes,
Yes,
please?
please.
The range of the diameter for the 6A bullet jacket fragment was .286 to .301 inches.
Okay, what page are you looking at?
It's page 13.
Okay. Now, so this is your documentation of the diameter measurement. And then on the right there, LIMP, that's measurement of the land width,
The
correct?
land impression width, yes.
And these are all general characteristics, or class characteristics, right?
Correct.
Okay. Now, once you had that and also that it was, you said, what's called the rifling was to the right, correct?
The direction of twist, yes.
Yeah, the lingo is 6 to the right, meaning,
6 right, yes.
yeah. And that's a class characteristic.
Correct.
So once you had the diameter of the base of the bullet, and did you have some difficulty because of the damage to the bullet in exactly measuring it?
The reason I provided a range was because of the damage and deformity to the base. So at times it wasn't a perfect circle, so it was important to me to give a range of what those diameter measurements were.
Once you have the diameter and the rifling characteristics and the land and groove measurements, can you then plug those measurements into a database and to narrow down the class of weapons from which this bullet could have been fired?
The general rifling characteristics search will use those class characteristics and will generate a list of possible firearms that could have fired the bullet. But that list is not all-inclusive, it is just used as an investigative tool.
Sure. Could you go to page 47, please? Could you tell us what we're looking at here?
This is the results of that general rifling characteristic, or the GRC search.
All right, and what did you determine in terms of, just based on the class characteristics, what weapons could have fired the 6A bullet?
There were several different .30 caliber class firearms that could have fired the bullet.
And they're listed here, correct?
Correct.
Could you tell us what the initials PI and RI and PR mean in the far right-hand column?
They refer to different types of firearms, so rifles, revolvers, machine guns, any type of firearm.
And what are the pistol ones? How is that designated? PI or?
Correct.
And what is RB?
Bolt action?
Bolt action. So based on the class characteristics, any of these weapons could have fired that bullet?
They could have possibly fired the bullet jacket fragment, yes.
Okay. Now, let's go back to the examination of the other two measures, subclass characteristics and individual characteristics. Is one of the reasons you look at subclass characteristics because they can be confused with individual characteristics?
That is a concern, yes.
In fact, your manual says that, right? It's important to rule in or out subclass characteristics to avoid the danger of confusing them with individual characteristics.
I'm not sure if our manual says it verbatim. It says that we do need to assess every piece of evidence for possible subclass characteristics.
And what is the reason for that?
Subclass characteristics can be similar to individual characteristics. However, trained examiners are able to notice the difference between subclass and individual. Subclass characteristics are not always present on an item. It's possible, but not always present. And they tend to look a certain way. They're going to be uniform in their appearance. They're going to be spaced in a way that's more uniform. If you think of circles, those circles could be a distance between each other in the same distance every time, and they will look almost the exact same every time.
Now, does your laboratory have certain protocols for conducting these comparisons?
We have procedures for comparison, yes, like taking photographs, yes.
Well, but also procedures for instance, you have a document called Examination and Comparison of Unfired and Fired Ammunition and Components that deals specifically with the procedures to be followed for the kind of examination you did here, correct?
Yes, I believe that refers to the minimal documentation necessary for a piece of evidence.
And one of those standard operating procedure requirements is document observations and evaluate for the potential of subclass characteristics on the relevant tool working surface, right?
Correct, yes.
And you did that in this case, correct?
I did, yes.
Okay. And what conclusions did you reach?
Can I refer to my notes?
Yes, please.
My subclass assessment that's on page 13 of my report states, stria observed in the land and groove impressions contain starts and stops, are not coarse, and vary in their height, width, depth, and spatial arrangement, no apparent subclass influence.
Okay. And what page was that again?
Page 13.
Page 13. Let me ask you about that. The striae observed are not coarse, I think I understand that, and vary in their height, width, depth, and spatial arrangement. Did you measure the height, width, depth of the land and groove impressions?
The land and groove impression widths, yes, I did.
And how about the striae? That's different than the land and groove impression, right?
Correct, yes.
You didn't measure the height, width, and depth of those marks, correct?
No, I did not.
Okay. And your protocol says, does it not, due to their similarity to and potential confusion with individual characteristics, it is essential that the evidence be evaluated for the potential of subclass characteristics.
It does, yes.
That's the whole purpose of why you're doing that part of the exam, right?
Correct, yes.
And anywhere in your protocols, does it specify what you're looking for, or is it just up to you to decide what is and what is not a subclass characteristic?
Subclass characteristics are a very large part of the training process to become a firearm and toolmark examiner. There are modules that are taught where you're trained to recognize what subclass characteristics look like, what manufacturing techniques might lend to more subclass characteristics. So I am trained to know what it looks like.
Okay, and my question though was, does your standard operating procedure set out, here are the things you should be looking for? For instance, does it say, if what the marks you're looking at are not coarse and vary in their height, weight, depth, and spatial arrangement, or if they're perpendicular on the barrel, that indicates that it's not a subclass characteristic. Is there anything like that in the manual?
No, there's not.
Okay. Did you inspect the interior of this barrel?
I did, yes.
And did you notice whether it had any debris or dust in it?
I believe my notes state that debris and dust was observed in the inside of the barrel, yes.
Okay, and could you further characterize what that was? Debris,
I think it says dust, so I would say dust.
dust. What can cause dust to get inside of a barrel?
A plethora of things. I'm not sure why something is ever in a barrel.
Okay. So you determined here, you ruled out subclass characteristics, correct?
Yes.
Then the next part of the examination was determining whether you had any individual characteristics on the bullet, correct?
Yes.
And what did you conclude in that regard?
That there were microscopic marks of value worthy of comparison, or yes, individual characteristics in the landing groove impressions.
And does your standard operating procedure have any guidance in terms of how you go about determining that?
No, I do not believe so.
Okay. And then once you determine that you have items of value on the question bullet, do you then do something to produce test bullets?
Yes, part of the comparison process when there is a firearm that we receive is to test fire it to make pristine samples to see if reproducible individual marks of value is on the bullet or the cartridge cases.
How many test fires did you produce in this case?
I made 3 sets, so 6 total.
Is that your standard number of test fires?
Our standard operating procedures state that you need at least 2. There is not a maximum number that we are allowed to do. It's the discretion of the examiner.
Were you informed by other investigators working on the case that this particular weapon was manufactured in Germany in 1938?
I was not, no.
You did not review a report from an ATF agent who investigated that issue?
No, I don't believe so, no.
In doing your examinations, is it important to know something about the manufacturing process of the weapon?
It is helpful to know how a barrel or any part of the firearm is manufactured, yes.
And why is that?
Certain manufacturing techniques will lend to that individual characteristics. So grinding is a method that is known to leave individual characteristics on a tool. So if an item that I receive, I can tell is finished or manufactured by grinding, it already gives me an indication that individual characteristics would be left from that tool to the tool mark.
Now, once you have your 6 test fires, then you did some comparison between the test fires, right?
That is correct, yes.
And why do you do that?
That establishes whether or not there are individual reproducible marks of value on the test fires. It's important to know that because if there's not reproducibility amongst the test fires, then there's a chance to say, oh, it's not going to reproduce on the evidence and I wouldn't have anything to compare it to.
And have you had cases where you fired the 6 test fires and you don't get reproducible marks?
Not that I can recall.
And when you do your comparisons, just looking at the test fires, do you get situations where there's some dissimilarities between those 2 fired bullets from your test fires?
Yes, there are at times there will be disagreement amongst the individual characteristics, even in test fires. You have to think of it as when a bullet travels down a barrel or a cartridge case interacts with a firearm, the marks aren't going to be left onto that item the same way 100% of the time. It's almost like a stamp. If you know you're using a stamp and you put it in ink and then you put it on 2 separate areas of an item, it might look a little different just from the way the stamp was placed. It's the same thing with a bullet traveling down a barrel or a cartridge case coming into contact with a firearm.
So even when you know a bullet is fired from the same weapon, you can have 6 bullets fired, and when you start comparing them, you will see differences between each bullet.
There is a possibility to see some areas of disagreement. However, if I'm rendering an identification and saying there is reproducible individual marks of value on these test fires, there will be an overwhelming amount of sufficient agreement of that individual characteristic.
Now, when you're doing these comparisons, you use something called the AFTE theory of identification, don't you?
Yes, the AFTE theory of identification.
All right, and take a look. And that's the standard that you used in this case to draw the conclusions that you made in the report that I showed you earlier, correct?
That is the theory stating how an examiner is able to come to a conclusion when examining 2 or more sets of tool marks. And yes, that is how I go through my examination and how I come up with my conclusion, yes.
Okay. And what is AFTE?
AFTE is the Association of Firearm and Toolmark Examiners. It's the governing body of the firearm and toolmark community, whose primary goal is to further research and continue to show information about manufacturing and the evolution of firearm and toolmark examination. They hold annual seminars, publish a glossary of terminologies used by the firearm community, and they also have a peer-reviewed published journal.
Peer review published journal. Can I join AFTI?
You can, most of the firearms community, or excuse me, members are firearm and toolmark examiners. There are also technical advisors and associate members. Those members are not usually firearm and toolmark examiners, but they still have a livelihood in firearm and toolmark examination, meaning they conduct research or they are involved in products or manufacturing. And anybody is allowed to come to the annual seminar or get the journal. You just have to pay the fee.
Just have to pay the fee. Okay. Could you display to the witness Exhibit 27, please? Do you recognize what's displayed here?
It appears to be the AFTI theory of identification, yes.
I move that into evidence, Your Honor.
What is it?
This is the standard that she used to make the comparisons in this case, correct?
Would this be Carner 27
This would be Carner 27, Your Honor.
to the state?
Your Honor, if I may voir dire the witness on this exhibit, I've never seen it before, I don't think.
All right.
Sure.
Let's go ahead and do so. Mr. McBride.
When was the last time you reviewed this document?
I'm not sure off the top of my head.
Can you testify as to its accuracy by looking at it now?
Not verbatim, no.
Your Honor, no more questions. My objection is lack of foundation.
Mr. Burt.
Does this document accurately state what the theory is?
May I take a moment to read through
Yeah,
it?
sure.
I believe something, I think the first statement is different than what I can recall, but overall, it is what the AFTI theory states.
Okay. And your ATF protocol refers specifically to the AFTI theory of identification, does it not?
It does, yes.
Okay. So is there any difference between what's in 27 and what's in your manual?
Again, I don't remember without looking at them side by side.
Okay. Let me get that in front of you. Let's go to Exhibit 12. And go to theory of identification and range of conclusions. Page 1 of 3. I don't have a Bates on it. Toward the end. It's document FT 10. No, that's not it. Can I approach your witness, Your Honor?
You may.
Page 1 of 3 of your protocol. I think what it's.
I recognize this as something that comes from our SOPs, yes.
Okay. And it refers to the AFTI theory of identification, right?
It does, yes.
Same theory that's displayed in 27?
Yes.
Okay, so I'd renew my offer on 27.
Your Honor, the objection stands. Language matters. Without knowing if this language is identical to what she's trained on, that can make a big difference. Whether the word sufficient or adequate is used, these are scientific principles, and we need to be precise in the language that's used. The witness cannot authenticate the exhibit that's been offered, so it should not be received into evidence.
Mr. Burt?
Goes to weight, not admissibility. You'd be free to question her about any differences, but I think she's laid a foundation that the theory's the same, so.
All right. Well, I remind the parties that this is a probable cause finding, and so as it relates to what's been presented, the witness has said that it looks familiar. Again, I don't want to quote you. I don't remember the exact phrase, but she recognized portions of it and then was given the opportunity to compare it to her standard operating procedure. I think she said SOP. For those reasons, Carner 27
Yes.
is admitted and may be
Thank you.
published.
Looking at the language of this, the second part of it, according to AFTI, says, currently the interpretation of individualization identification is subjective in nature. Do you agree with that?
Yes.
Why is it subjective in nature?
The conclusions that I author are of my opinion.
Of your opinion?
Correct.
Does your, you can take that down, thank you. And no, wait a minute, go back if you would. But while he's doing that, does your manual state what you're looking for under this theory is correspondence of individual characteristics?
Yes.
That the theory is that if you see a certain level of correspondence, you can make a source identification, but not to the exclusion of all other firearms in the world, correct?
Correct.
Okay. And the standard, at least as it's articulated here, is the theory as it pertains to the comparison enables opinions of common origin to be made when the unique surface contours of two tool marks are, quote, in sufficient agreement. And is the subjective part of that, the quoted part, sufficient agreement?
The subjective part of the conclusion is saying, yes, it is my opinion that there is or is not sufficient agreement or sufficient disagreement amongst two or more tool marks.
And what may constitute sufficient for you may be completely different from the next examiner. Fair?
Yes and no. I would expect any trained, competent examiner to come to the same conclusion. So the threshold of sufficient agreement might be different from one examiner, but the conclusion I would expect to be the same.
Does your manual state, your ATF manual, section 431, state that correspondence or lack thereof of individual characteristics is not easily communicated? An observation such as significant agreement can mean different things to each examiner. This does not serve as interpretable descriptions of what was observed because the individual performing the review will likely have his or her own concept of the phrase based upon their training, experience, and knowledge.
Objection, Your Honor. This question goes to weight. Oh, I'm sorry. You don't want, maybe heard.
If you're objecting, I will hear the objection.
It's just speaking objection. That's why I stopped myself. This goes to weight. This goes to credibility. And the witness's report has already been admitted as is appropriate under the Utah Constitution, Rule 7B and Rule 1102 of the Rules of Evidence. This is beyond the scope of preliminary hearing for those reasons.
Mr. Burt.
Number one, that's a general objection, which I think has been waived. The state was privy to the interview with this, pre-hearing interview with this witness where these same questions were asked. we had a scheduled hearing where the court was going to rule on objections. The state indicated in advance of that hearing that it had no objections to the testimony, reserving the right to make particular objections. But the objection being made is a global one. And it's relevant because the state offered, the evidence I'm offering here is relevant because the state offered through a hearsay declarant the meaning of this report that this examiner authored. And I'm trying to inform the court on what the limitations are of the opinions expressed in the report that the state offered. And it's certainly relevant to the reliability issue to know that the opinion is based on a subjective standard that the witness herself admits is subjective. So I think it helps the court understand what weight, if any, to give to this report that the state offers.
All right. Mr. McBride, final thought.
That's all fine, but it's inviting the court to weigh the evidence. That's the whole point. And at this point, the inferences are drawn in the state's favor, and the court is not to weigh even contrary evidence.
Okay. Well, in regards to whether objections have been waived or not, the court as the magistrate bears the ultimate responsibility to ensuring that this hearing is a probable cause standard. And so that's a responsibility that as a magistrate I take seriously. I understand the arguments from the parties. I'm going to overrule the objection, but Mr. Burt, this is, we don't need to go 100 miles down a path where 1 mile is where probable cause may be. And so I invite you to refocus, to bring it
Sure.
to the probable cause. I'm not trying to limit what your theories or such, but I need to hold to probable cause.
Absolutely, and I don't even need a quarter of a mile. This is my last question, and I'm going to move to another
All right.
topic.
Thank you, Mr. Burt.
Is that what your manual states?
I don't remember it verbatim, but it does sound accurate.
Well, could you pull up Exhibit 12, page? Just to, can I approach again?
You may.
I can give you 2 pages quicker. Bottom of the page, highlighted.
I see where you were reading from, yes.
You see,
Yes,
did I accurately read it?
I believe so, yes.
Thank you. Can I approach you?
You may.
Okay. Now let's return to the report, the People's or State 32. And if you would go to the second page, please. You concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics. The result of the comparison was inconclusive.
Yes,
That was your ultimate conclusion, right?
yes.
And on the next page, if you could go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page, one more. There we go. I want to ask you, because I'm unclear on what inconclusive means. You say, reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification, a lack of any observed microscopic similarity, or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There is a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the land and group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I have met before today, correct?
Yes,
Where we talked about what that term inconclusive meant, correct?
yes.
And I think, and correct me if I'm wrong, but did I read to you from a do you recall me asking you whether you agreed with this statement, that an inconclusive conclusion indicates that the microscopic marks in question may or may not have originated from the same or known source?
I do remember you asking, yes.
And you agreed that that was a correct definition of what you concluded in this case, correct?
Correct, yes.
Okay. So I want to, if I could, return to 10, Exhibit 10. And in Exhibit 10, not 10, I'm sorry, your case file again. This is the 47-page document. There we go. What's the tab? 6. Okay. In your case file, you have produced for us some nice comparison photos of your comparisons, correct?
Yes.
Okay. And if you would go to page 37. Is the top photo depicting one test fire on the left and another test fire from the same gun on the right?
Yes, it is.
So do you see areas of agreement and areas of disagreement in these two bullets fired from the same rifle?
I see sufficient agreement amongst the striations that are in this land impression.
Okay, and tell us where they are. When you draw that conclusion, using this subjective theory of identification, show us what you're looking at.
Is it touchscreen?
Probably,
No, it's not.
No.
I'm sorry.
but we can, if you direct us, we can get there with a pointer.
Sure. So you can see towards maybe the last third of the bullet or the land impression that, yes, right where your cursor is below there, that's an area of agreement with that striation. It looks like it's going from the left to the right, so that mark is appearing on the test fire on the left and the test fire on the right. Then if you look towards the top of that land impression, there's going to be some more lighter colored striations or lines that are moving from left to right. Those areas are in agreement as well.
Where is that? Not as far up as where he is, correct? It's down?
Yes, and I believe the PowerPoint that I provided does have some areas and circles of some of these marks, if that would help as well. But if you move your cursor up, continually up, keep going. There you go. You have a line that was right there, and you have several others underneath of it that looks like it's going just straight across from left to right, and that shows an observed area of agreement.
So that one he's got circled on the right, I see a line there. Are you saying you see a line on the left that it's identical to the one on the right?
I'm saying I see agreement amongst those striations, yes.
Okay, anything other than those two areas?
You can really go down the entirety almost of that line looking at those striations. So under the top red circle, there's another area there. Yep, if you start right there and you draw your circle over, like I said, at the top of the circle, there's a highlighted line on the left that goes all the way to the right. If you go a little bit farther down, maybe still in the top third of that circle, you can see another line going from one side to the other, another area of agreement as well. And then under the final third circle, in a little darker area down there, there's still some lines, again, in sufficient agreement.
Okay, and again, these are comparisons between test fires. So you know the rifle that you're test firing fired these two bullets, right?
Yes, and the
Okay.
purpose of those test fires is to ensure that though it was fired from the same firearm, you want to make sure that those individual characteristics are reproducing.
All right, so go to the photo on the bottom of that page. This is the first of several comparisons between the test fire on the left and 6A on the right, correct?
Yes.
And what does the writing on the top mean, blue index GIMP?
So that will be, the first number there is the case number, the laboratory case number. Then next 1.11B is going to refer to the specific test fire that's on the picture. And then V versus 6A, so that's the evidence that's also pictured. GIMP stands for a groove impression, so I'm looking at a groove impression in this photo. Blue index means that I'm specifically looking at the groove impression that I have put a blue indexing mark on so that I know where I am during the comparison process.
Okay.
30X refers to the magnification that the photo was taken at, and then INC refers to inconclusive, the final conclusion.
So I'm interested in the areas of disagreement. Are there areas of disagreement between the known and the unknown here that you could point us to?
So for this photo, to me, I see areas of agreement in the top. And then on the way down from the 6A, right after you see those two highlighted lines near the top, there is a lot of damage that is observed, and almost no microscopic marks of value can be observed at all. So again, that lends to the lack of quality and quantity of marks even to do a comparison. It's almost like missing data points.
Okay, missing is not the same thing as dissimilar though, right?
It just means there's nothing there to call agreement or disagreement.
So do you see areas of disagreement here or no?
On the striations that are available to me on this groove impression, I see areas of agreement, and specifically talking about those two highlighted lines at the top on the right.
Okay. Go to the next page, please. Top photo on the next page. It's B38. You see areas of disagreement in this photo.
So this is the same photograph that we looked at before, just at a different magnification. It's zoomed in a little bit more from 30 to 40x. So again, I'm looking at those two highlighted lines near the top, and then if you look down, you can almost see that damage a little bit better, and there's none of those striated lines that you see on the test fire, which you would expect to see in a Lander groove impression on the right at all. So again, no microscopic marks of value to compare whatsoever.
All right, how about the bottom photo? And again, the question, areas of disagreement.
The possibility of an area of disagreement maybe in the middle. There on the 6A is a line that does not look like it carries over, but just from this snapshot, I cannot say if I had moved the photo a little bit different or the specimens together, that area would be agreement. In this photo, it does not look like it does, though.
Okay. And could you go to the next photo, please? Same question here, areas of disagreement.
The way this photo was taken is highlighting more of the lack of microscopic marks of value. If I had pulled the specimen that's on the left, the test fire over, there might be some agreement that could be observed, but the way the photograph is now, You don't see the line on the right going all the way over, but again, this is just a snapshot of one particular area.
Doesn't show areas of agreement or disagreement.
There is an area of agreement at the very bottom of the photo.
Okay.
Correct, yes.
Next photo, please. How about this one?
This is another zoomed in of the previous photo, focusing in on that bottom area of agreement. So we went from 30X to 40X and just highlighting one specific area, and this is showing you agreement.
Next photo.
So again, this area that is highlighted, the bottom portion that's in focus, is showing an area of agreement. As you go up, the lines are a little bit blurred on the 6A bullet jacket fragment, so it's hard to say if that area was an agreement or disagreement. That's not what my photo was focusing on.
All right. Next one.
So again, this is going to show you part of the groove impression at the white index. On the top, you can see some striated lines, or excuse me, more of the middle of the photo. The top of the groove impression from the 6A, you see some lines do not appear to be on the right side either, but this photo is also trying to show the lack of microscopic marks at all towards the bottom of that groove impression.
Okay. But there are in these photos areas of disagreement as well as areas of agreement, correct?
In the photo that we just looked at, it could be possible areas of disagreement. Again, it's just one area that I'm looking at. It's hard to tell when you can't look at the entirety of the land in this moment.
Now this, you can take that down, please. Do you keep up with the literature relevant, scientific literature relevant to your field?
I do, yes.
And are you aware of certain criticisms that have been leveled against this AFTE theory of identification?
I have heard, yes, I've heard recommendations on how to improve the AFTE theory of identification, yes.
Well, the criticism have gone beyond that, right?
Specifically, what are you referring to?
Well, you're aware that the National Resource, the National Resource Council?
The National Academy of Science?
National Academy of Science?
Yes.
Is that a pretty preeminent scientific organization in this country?
Yes.
Did they conclude in 2009 that, quote, a fundamental problem with toolmark and firearm analysis is the lack of a precisely defined process? As noted above, AFTE has adopted a theory of identification, but it does not provide a specific protocol. It says that an examiner may offer an opinion that a specific tool or firearm was the source of a specific set of tool marks or a bullet striation pattern when, quote, sufficient agreement exists in the pattern of two sets of marks. It defines agreement as significant when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. The meaning of exceeds the best agreement and consistent with are not specified, and the examiner is expected to draw on his or her own experience. This AFTE document, which is the best guidance available for the field of tool mark identification, does not even consider, let alone address, questions regarding variability, reliability, repeatability, or the number of correlations needed to achieve a given degree of confidence.
I do remember
Objection.
there's...
Objection. We're now firmly into 702 territory. I object on grounds of relevance to the probable cause hearing and beyond the scope of the PC hearing, as I previously objected.
I think it goes directly to reliability. That a group scientific group studied this exact process that she used in this case and reached that conclusion?
If you would, so again, I'm trying to keep us on the probable cause standard. This is going a bit deep in regards to it. This is citing to 2009, and so we're in 2026. And again, I don't want to have to dive deep into areas trying to determine, because I feel that we are exiting the orbit of probable cause. If I'm having to make that analysis and trying to see, like, how is this relevant? How does this apply? How does this go to probable cause? So if you wish to ask this question and then move on, we certainly could do that. But
Sure. The only thing I wanted to do was establish that this was the foundation criticism in 2009. And I know when we had raised this issue with respect to one of the other experts, the comeback was, oh, well, this was in 2009 and the PCAST report was in 2016. In this particular field, these criticisms have started in 2009, but they have continued up to the present day and have gotten more strident. So I think that's the take home here, is that this is not some past criticism that has been set aside. This is a criticism that this expert is aware of and that has continued in the literature up to the present time.
But I don't have that second portion of what you just said in front of me. So I can't agree with you, because what I have is what's before me. I can't go searching myself as a magistrate for probable cause. I have to take what you say as it is. And if I have to start searching, I've left the universe of probable cause.
I agree, and I was offering that to the court as a proffer in terms of where this line of questioning is going, so the court can understand the context.
Okay.
It isn't just an isolated criticism, and I'll establish with a couple of questions that it's continued up to the present time.
So I will overrule the objection, but I will limit you to this question. We're going to more and more and more. I see your point. You're looking at whether this science is challenged or not. The point's been received, but anything further goes outside of probable cause. So we have to get back on the path.
Got it.
Thank you, Mr. Burt.
You're aware of that criticism, right?
Yes, I am.
And you're also aware of the criticism leveled in 2016?
Counsel, I just said that we're focused solely on, I've accepted what you've said, but I said that it's limited to this question, and then we're moving on, because anything further is going outside of probable cause.
I misunderstood. I apologize to the court.
And I apologize if I wasn't clear on that, so maybe it was my error not communicating. I've accepted that coming in. I've overruled the objection, but I said we're gonna leave that where it is and then move forward.
And that's where I'm unclear. When the court says move forward, no more questions about any further criticisms beyond that one?
On this line of question, that's correct. Because
Okay.
Thank you,
All right.
Mr. Burt.
And I think I've made the proffer in terms of the relevancy of it.
And I accept that, so thank you, Mr. Burt.
All right, then the last area is, in the years that you've been doing this testing, is it true that you've only taken one proficiency test that involves bullet comparisons?
Yes, I've only had the opportunity to take one bullet proficiency test so far.
And is it true that that was in 2023?
I don't remember the exact year, but that sounds correct, yes.
Right. And is it true that that proficiency test involved a test where you had question bullets, and then you had two sets of bullets, one that was fired from one gun, not the suspect gun, and then a second gun that was fired from another gun?
I don't remember the exact final ground truth answers that were there. No, I'm sorry, I don't remember.
I think when you and I talked about this, you said you were aware of a controversy about that particular test, correct?
I was aware, yes, of the results of the proficiency test, yes.
That there was a very high error rate in that particular proficiency test, right?
There was a higher error rate, yes. However, my answers were satisfactory, along with the 5 other examiners at my specific laboratory that took it as well.
Your conclusion in that case was, as in this case, that it was inconclusive, correct?
Correct.
Even though the correct answer was that the bullets did not come from the question, the 2 did not match, the known in the question should have been an elimination.
The ground truth answer was yes, they were excluded. However, an inconclusive result in this comparison was extremely appropriate. The lack of quality and quantity of those individual characteristics never reached sufficient agreement, nor did it ever reach sufficient disagreement. So saying anything but inconclusive was not appropriate.
I see. And can you have bullets fired from different weapons that can have individual characteristics that look pretty similar?
There is occasions, yes, that tool marks that are made by 2 separate tools are similar, yes.
Could you go, and this is my last area question, Exhibit 19, page 26?
Your Honor, I'm requesting
Page
20 minutes
26.
for cross-examination. We're coming up on 4:37. That would be my request, Your Honor.
This is my last question. So.
All right, Mr. Burt. Thank you, Mr. McBride. I appreciate the heads up.
In your opinion, does this, the one on the left and the right, show matching individual characteristics?
Counsel, has this been admitted? Because I see it displayed. I just want to make sure, is this also?
It has not been admitted, and
Okay.
I'm asking this question and as a foundation for admitting it.
Okay, that's fine. So I just
Yeah.
want, it was on another screen. I wanted clarification, so it's not on any screens because it hasn't been admitted, but clearly it can be on her screen.
Thank you.
So only to the witness and counsel table screens.
Page, Exhibit 19, page 26. Does this comparison show individual characteristics indicating that it was fired from the same weapon?
There are individual characteristics present, but without examining it in person, I don't feel comfortable making a conclusion.
Okay, how about the next page? Watch, 27. How about that one?
Again, I see individual characteristics. On a very first glance, I can see maybe one striation that is an agreement, but without seeing it physically in person and having an accurate representation of the entirety, I can't conclude in any answer.
And the last one, the third photo, page 28. Page 28. Exhibit 19, page 28. Same question.
I do see individual characteristics. I do see some areas of agreement without looking at it further. I wouldn't make a conclusion. It's a holistic approach when you're examining items.
Would it surprise you if I told you that all 3 of those were fired from different weapons?
Again, I don't know any context to these photos other than what you showed, so I don't feel comfortable saying one way or another.
Thank you.
Good afternoon.
Those last 3 photos that you were shown, had you seen those before?
I have looked at them probably back in 2024 when it was published.
Okay, that's a study. Is that what that is? Of some sort?
Yes. It was a look from the Association of Firearm and Toolmark Examiners. It was a volunteer of photographs of people that did have an incorrect answer in that proficiency test.
Okay. And when you do an examination or a comparison, are you limited to one photograph?
No.
You actually have the item in front of you, correct?
That is correct, yes.
And you can manipulate it, you can turn it, you can look at every angle and every side of that item as you do the comparison. Is that correct?
Yes, that's correct.
And as you're doing that process, you're looking for as many characteristics that match or agree or disagree as you can possibly find, correct?
Yes, it's a holistic approach. If I have a bullet like this case, I'm looking at every single land, every single groove impression, and doing an evaluation of each one of those, looking for areas of agreement and disagreement before rendering a conclusion.
Would it be responsible for you to reach a conclusion based on a single photograph of a very limited area of 2 bullets?
I would not feel comfortable doing that now.
Okay, I want to back up. How long have you, first of all, where do you work?
I work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
How long have you been there?
A little over 6.5 years.
Where did you come from? Where did you work before that?
Prior to working for ATF, I was a latent fingerprint technician, recovering latent fingerprints from improvised explosive devices, and I also worked as a crime scene investigator in Winston-Salem, North Carolina, and Anne Arundel County, Maryland.
How long did you have that position?
I think cumulatively it was about 5 to 6 years.
And before that?
Those are the only ones. I think it was about 6 months as a latent fingerprint technician, 2 years as a crime scene in Winston-Salem, and 3 in Anne Arundel County.
Do you have education and training before that position?
Yes, I have a Bachelor of Science in Forensic and Investigative Science from West Virginia University and have attended and graduated the National Firearms Examiner Academy, as well as done specific training at my laboratory.
At each of the positions you've held, have you had on-the-job training at the laboratories where you've worked?
I have, yes.
And will you describe what that training is like at the ATF where you are now?
Yes, so part of becoming a firearm and toolmark examiner for ATF was attending the NFEA, the National Firearms Examiner Academy, which is a year-long intensive comprehensive training program. I learned about historical cases, figures, and the evolution of firearms, fired ammunition components, and manufacturing. In phase 2, I worked 16 weeks of hands-on experience assembling and disassembling firearms using a comparison microscope comparing fired ammunition components and tool marks, going on manufacturing tours, and participating in moot court. I worked on an independent research project and 4 practical exercises, and then presented that independent research project to a panel of experts and participated in 2 moot court sessions on 2 of those 4 practical exercises. Then specifically for ATF, I still work on my training, going through practical exercises and competency tests, working under trained firearms examiners at my laboratory, and also continue learning about any manufacturing evolutions or going on manufacturing tours. And I also participate in moot court for every single competency test that I work. Once all of that is complete, then I work on supervised case before moving on to unsupervised casework.
And supervised casework means what?
It means that the author of the final report will be a different examiner, but I am working on all of the work side by side and going through all the steps that are needed for that examination.
And in that process, you're having discussions and discussions about your work with a more experienced examiner.
Yes, it's an opportunity to work a case that has come into the laboratory, but still have someone there making sure I feel comfortable with everything and following every step necessary.
How long ago was that you had that you graduated from that supervised work?
I believe that was in 2022 or 2023. I'm not sure.
Do you supervise now others?
I do not have a supervisor capacity, but I have had the opportunity to now teach at the NFEA. I've been fortunate enough to participate as an instructor in the test firing module, the mini moot court module, and the comparison of bullets and cartridge cases.
Are you required to undergo continuing education in your position?
There is not a specific continuing education program. However, when the opportunity to go on AFD's annual conferences and it allows it, I will go to those, as well as continually go to manufacturing tours.
Is this an area of science and forensics that is continuing to develop new techniques and advance in research?
Yes, it is.
And how do you stay up on those advances?
Part of the way to do that is to continue my membership with AFD. Again, they do an annual training seminar recently, just in May of 2026 here in Baltimore, where there's case searches and studies that are presented, different manufacturing techniques, just new and upcoming research that is throughout the community, not just firearms practitioners, but also standard and technology researchers like those from the National Institute of Standards and Technology, or NIST.
And I think Defense Counsel has asked you a little bit about some of the publications that have given criticism is how he's phrased it, but given recommendations on how to improve the science in your field. Are you aware of that?
I am, yes.
And is there an effort to adopt those suggested improvements where they have merit?
Yes, AFD especially takes those recommendations very seriously. If the PCAST asked for more specific design test studies, they said, yes, we will do that. I can think of just a few right off the top of my head that has satisfied those asks that they wanted.
Is your laboratory accredited?
It is, yes.
What does that mean to be accredited as a laboratory?
And accreditation means that my laboratory is held to an international standard of reporting, testimony, training, and proficiency tested. We have a large audit every 4 years through ANAB, or the American National Standard Institute, National Accreditation Board, but we also do internal audits, and we make sure there is some type of audit that we are staying in within those accreditation limits every single year.
There is a mention of proficiency testing. Are you required to do proficiency testing?
Yes, I am.
And are those specific as to what type of proficiency testing that you do?
Yes.
What are some examples?
We are required to take proficiency tests in all discipline that our scope enables, so serial number restoration and the comparison of tool marks, bullets, and cartridge cases.
Are there similarities and principles that apply to all aspects of tool mark analysis and comparison?
Can you elaborate on the question, please?
Well, let's say you're comparing what we've been talking about here, rifling on a bullet. Are there principles that apply to that area versus that also apply in tool marks analysis, say of impressions of a handheld tool?
Yes, all of those comparisons are a product of a tool mark comparison. A firearm is nothing but a tool. So when you are talking about a cartridge case comparison, it's still looking at a tool and a tool mark. The tool in this case is the firearm. The tool mark is being left on a cartridge case or a bullet.
I want to draw your attention to Plaintiff's Exhibit 32. Thank you. Well, that's pulling up. And this has been published, this has been approved for publication at all 3 levels already, so we can put that on the screens. Well, that's pulling up. Thank you. I want to ask you first about an entry here. The second sentence under results of examination. Exhibit 1 is rifle was test fired and found to be in operable condition. Did you perform that test fire?
I did, yes.
How did you receive this firearm?
I received it from another physical scientist in our laboratory.
Okay. And did it have a scope on it?
Yes, it did.
What did you do to determine if it was in operable condition?
In order to determine if the firearm is in operable condition, I will find ammunition that it is calibrated for. In this place, it was 30-06 Springfield. Load that into the firearm, and then I fired any test fires into our water recovery tank.
Okay. And why did you choose a water recovery tank?
The water recovery tank is what is used to obtain bullet specimens. The water is going to slow down the bullet from its movement so that we can actually obtain the bullet, and it is supposed to cause minimal damage.
Why does it matter if there's minimal damage or more damage?
You would like minimal damage because that means that there's going to be less damage on the areas that you need to compare.
And the evidence rounds that you, or in the bullets that you often receive in your cases, are there cases where there's a lot of damage to those bullets?
I have received cases with lots of damaged bullets, yes.
In this circumstance, the Exhibit 1 rifle, this Mauser 98 30-06, was it an auto-loading rifle or a bolt action?
This was a bolt action rifle.
Exhibit 2 cartridge case. Let's see here. If you'll turn to page 2, and we've already read this line. I think defense counsel read this line to you, the Exhibit 6A paragraph there. The result of the comparison was inconclusive. Could further testing be done to try and see if there is any, if you come to a conclusion on this round?
There was no further testing that I could do, no.
Is there further testing that could be done in the field?
There is the possibility of using a 3D system to visualize the individual characteristics on the bullet.
Do you have the capability of doing that at your lab?
My laboratory currently does not have that capability.
Do you know if the FBI lab does have that capability?
I believe they do.
Defense counsel put up a list of potential firearms that could have fired this round, or this bullet. Is that list comprehensive?
It's not an all-inclusive list.
And does it mean that this round, I'll leave it at that actually. There's been some discussion about the 6A bullet jacket fragment. Will you describe what a bullet jacket is?
Yes, I do have a demonstrative. May I use that?
Do you have that with you?
Yes.
Yes, please, go ahead.
So this is a demonstrative of a bullet. So a bullet jacket, it would refer to the outside of the bullet. Inside the bullet would be the lead core. So when I'm referring to the jacket, it means that I've only received that outer portion. I did not receive any of the lead core intact with it.
In this circumstance, you received a bullet jacket fragment. What does that mean that it's a fragment?
Fragment means I don't have the entirety of that jacket.
And can you testify as to why you don't have that entirety?
No, I cannot.
And it also, your report also says that there are 4 lead fragments. What is this? Why would you have lead fragments?
So the lead fragments, the lead would be from the inside of the bullet, that core. Occasionally when the bullet reaches its final destination, it can split, and some of that core might be pulled off of the jacket and be found where it landed.
And would you be able to gather information from those lead fragments that could identify them as coming from this particular firearm? Would you expect to be able to make that comparison?
I would not expect to see any characteristics that would help me reach a conclusion, no.
Why not?
Because the lead core is on the inside of the bullet, the landing grooves are going to be imparted onto the jacket or the exterior. So when it's moving down the barrel, the inside is not coming into contact with rifling whatsoever.
In this case, do you have a verification step where your work is reviewed by another analyst?
We do, yes.
And were your conclusions in this case verified by another analyst?
Yes, they were.
Is there a potential that the testing you do can destroy the evidence that you're reviewing?
What do you mean?
Well, prevent it from being tested in the future.
No, I would not expect anything that I've done to prohibit more examination in the future, no.
But in general, you say you peeled back the petals, I think you said, of the bullet jacket because it was so crumpled. If that's,
Yes. I think if anything that lends to a better comparison process. It is a very well-known practice amongst firearm and toolmark examiners. Without doing a examination like that in preparation, no one's able to see the marks that are needed for the comparison process.
Okay. In reaching the conclusions that you did in this case, did you follow the protocols and practices that are required by your position?
I did, yes.
Nothing else?
Mr. Burt.
You said a couple of things of interest to me. One was that your work is peer-reviewed, right? There's a peer
Specifically?
reviewer, a second reviewer,
It is a verification process.
verification process. And you know, in this case, we requested to produce the case file from your reviewer so we could see whether it was accurate or not. You're aware of that, right?
I am not, and the verification process does not require that the verifier has case notes. Their case notes would be within mine, and it's just an author verification chart.
Well, you wrote a memo to Mr. McBride dated May 19th, did you not, in which you said in answer to our request for the reviewer's work product that ATF laboratories do not release materials concerning technical reviewers or verifiers. And you went on to state, did you not, that we don't even release the CVs of who the reviewers are.
So that is not authored by me. That is our ATF procedures and protocols. If that was an email that came from me, I am just verbatim what our quality assurance manager has said.
Do you think science works best when it works in secret?
Objection. Objection, argumentative.
Counsel?
It goes to the issue that was raised on cross-examination, which is my work was peer-reviewed. So how do we evaluate the strength of that assertion when they refuse to hand over to us the work product of the reviewers, or even identify what their credentials are? That's relevant.
Well, I'm not agreeing or disagreeing with that, but the question itself was argumentative. Because we can look at the question, working in secret
Let me
is...
rephrase.
Okay, so I am going to sustain the objection because of the phrasing. It is inherently argumentative, and it wouldn't be a question that would be able to proceed into prelim.
Do you have an opinion on whether it is scientifically defensible to rely on a peer reviewer and not reveal that peer reviewer's work product?
I believe I understand what you're asking. However, in this case, the verifier does not have any work product to show. If you'd like to see their CV, I cannot testify to anything about the procedures of giving their information out. All I can say is that they are employed at my laboratory, are under the same scrutiny of proficiency testing, went through the same training with competency and practical exercises, so they are a trained and competent examiner.
Right. They don't have any work product to show, but your protocol calls for, does it not, documentation of whatever it is they did.
And that is included in my case file.
Right, but not the reviewer's work product.
The reviewer's work product is a verification sheet. If you'd like, I can refer to my case notes and find that specific page number, but that would be the only work product that they would have in this case.
I see. Now, you said two things about the PCAS report on cross-examination. One was that, if I understood it, that the PCAS findings have been addressed in subsequent studies. Did I hear that correctly?
Because one of the recommendations was to further, actually, I think their recommendation was one more black box study to show the foundational validity of firearm and toolmark examination, and since 2016, several have been published.
All right, let's look at that for a second. First of all, they didn't recommend, they found, did they not? Quote, PCAS finds that firearms analysis currently falls short of the criteria for foundational validity because there is only a single appropriately designed study to measure validity and estimate reliability. The scientific criteria for foundational validity requires more than one such study to demonstrate reproducibility. Isn't that what they found?
That is what their finding was, correct.
Okay. And then after that report was published, in 2017, they came out with a second report because people said, oh, the literature already exists, you missed it. And they said, no, that's not true. Isn't that right?
They
Objection,
concluded,
relevance to preliminary hearing. We're now well into 702 argument.
He raised this issue on cross, Your Honor. He clearly went beyond the 2009 reference that the court allowed and opened this area up. And I don't think it's fair for him to be allowed to do that without me being able to respond to it.
Recross or redirect, however we want to label this. So you may proceed. The
Thank you.
objection is overruled.
In 2017, they filed a second report responding to assertions by people in your profession and others that they had missed or the studies had already been done. Isn't that true?
yes, PCAST did a 2017 addendum to their 2016 report, reiterating that they believe that the only way to properly empirically test a science is through these black box studies, and that they would not take into consideration the numerous amount of work and validation studies done over decades that the firearms community has published.
And a bunch of other studies were done, right?
Correct.
And in response to those additional studies, there have been continual criticisms of the methodologies of those studies. Isn't that fair?
Yes,
And you've read, for instance, well, first of all, you attended, I see, a webinar by the group that did some of the critiques. Remember that?
which webinar are you referring to?
You attended a webinar, I believe, in 2023, Treatment of Inconclusive Results and Error Rates of Firearm Studies. Webinar hosted by the Center for Statistics and Applications in Forensic Evidence, 2021,
Correct, I did.
according to you. And that group has published a number of studies right up to 2026, for instance. Their study in 2024 called Methodological Problems in Every Black Box Study of Forensic Firearm Comparisons, in which they concluded that the field still was not reliable despite the studies that you reference. Isn't that true?
That is the author's opinion, correct?
Right. And they're not the only ones. There have been other groups of statisticians who have published articles right up to 2026 saying that the studies that you referenced are unreliable. That their
Yes.
methodology of those studies is flawed and cannot be relied upon to support the science of toolmark comparison, correct?
Yes, there has been studies to say that they believe there is flaws in the black box studies and stuff, but there has also been plenty of research done to say the opposite.
And lastly, you mentioned that, or it was brought out that you have training and experience, right?
Correct, yes.
Do you agree with the conclusion stated in the section of the report, the PCAP report, that neither experience nor professional practices can substitute for foundational validity? Do you agree with that?
I do, yes.
You agree with the conclusion reached in the PCAP report that a forensic science discipline that has an error rate higher than 5% is not reliable?
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as a percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity. Proficiency.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAST said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damaged samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
But you would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right, okay, thank you.
Thank you. Anything further for this witness? And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you open the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer-reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct.
Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlyn Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer so I want to make sure your voice is projected? Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA Section Chief.
And how long have you held that position?
I've been a Section Chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence? For instance, the next sample down, 1.2, where the state read paragraph D, admitted paragraph F, you state in F, based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor, there might be concern about the actual monitors, the counsel table, and the podium. Any clarification on that?
Well, that's why I give my notation at the beginning of the morning that the parties are responsible to monitor their monitors. And that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Nye on behalf of the victim representative. We cannot see it in court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this
It's not
one.
being published on the monitor to the court's right.
Right, the order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct.
Well,
Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you, I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing. And the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you, I appreciate your concerns. Mr. Burt.
Thank you. Could you redisplay Exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that, from the FBI, testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency, so there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is ATF's, what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio, to speak to that uncertainty with a statistic.
All right, and would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty,
Correct.
correct? Now, when, you can take that down. When did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay, could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures, such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations, in addition to the one we just reviewed, that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify, essentially, what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap, and they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I
Okay.
agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios, on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded, so there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey that DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swabbed?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults, so things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to, say, swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive, and so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page 4, which is the table. I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there's support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
was-
not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swap number 1.6, or a profile that indicated he was a possible contributor.
There's support for inclusion of Matthew Robinson.
Okay. And next page, actually go page to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for Next Generation Sequencing. It's a DNA technique that sequences your DNA, so it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals, and there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one, what's the exhibit on this?
This is 154 in the second page.
Okay. You're familiar with this chart, right?
I've reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to the
thing.
first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STRmix, the STARmix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed, and we'll go from there.
It's true, is it not, that at least 5 of the locations of interest in this case, researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length?
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection.
Sure.
And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends
Again,
on.
objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. A likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever?
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my, my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you used the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
It's possible for them to present, yes.
Well, it doesn't say it's possible. It says, for example, approximately, in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures, based solely on number of alleles present.
You said you're referencing my SOP?
Yes,
Is it possible for me to take a look at it?
sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring
question
up
could be rephrased.
one, exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible. Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes,
The methodologies used in this case have been accepted by courts across the country, correct?
correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report, and this is, it looks like report number, or exhibit number 30. If we can pull that up, just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for, evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
The 1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations or the statistics at 1 trillion, is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, I'm sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly, and 2.1 is the swabs of one 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case, is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired, cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of two individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Okay. Nothing else?
Is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct, so they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person, can't state it's infallible, can't state there's a 0 error rate, and you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.